Our next case is State versus Clark. Each party will have 15 minutes to present their argument. Counsel, I'll be keeping time, Mr. Clark, I'll be keeping time up here. So I'll let you know. Do you want to have any time for rebuttal to reserve?
Oh, sure.
You can have up to 5 minutes. How long would you like to
5
reserve?
minutes.
5 minutes? Well, I will let you do, since you can't see the clock and I can, I will let you know when there's about a minute left in your initial 10 minutes.
Okay.
And that way you know to wrap up if you're getting close to that. And I'll let you know about the same when a minute left in your time.
Thank you.
The arguments are being recorded today. So when you come up to the podium, please introduce yourself. Please stay behind the podium because if you move a lot, we'll lose you both visually and audibly, and that'll affect the recording.
Okay.
It really shouldn't matter in this case. I don't think we have any children, minors, or victims in this case, but if you were, please refer to them by initials rather than people's full names if you would. With that, Mr. Clark, we're ready to proceed whenever you are.
Okay. Yeah, hello, Your Honor. This case, this appellant case, appeal that I brought out against the state, which I was found convicted, I was found guilty of, convicted of ORC 451121D5. That statute says that I violated the posted speed limit. In my brief, my first brief, or not my response, but my brief, I provided case law on a subject that you guys have had in front of you. Minnie Judge Carr, she wrote the decision for that, I believe, which was State versus Krantz. In State versus Krantz, the officer, I think it was Harris, he testified that the speed limit was 55 miles an hour on Route 30. He also testified to a speed limit sign outside of the stop. He also testified that he believed the speed limit was 55 based upon the type of road it was. I think he said it was a county road. What this court made clear in that decision, it says we're compelled to grant the appeal basically because the evidence demonstrated that there wasn't a posted speed limit sign in the area of the stop. And although there was some nebulous testimony of Trooper Harris about speed limits on other portions of that road, that they did not determine that there was the evidence did not present that that portion of the road where he was stopped was 55 miles an hour. I think that case is similar to this case, with the exception of I think that was under D1, and D1's 55 miles an hour on maybe like a 2-lane route. This was, the state never established how many lanes. They never established speed limit signs anywhere. Trooper Schmall in this case stated that he didn't think there was any speed limit signs in the area to stop.
Well, I understood his testimony to be, I know there are posted signs, I just don't know where. That's how I would sum up his testimony. He couldn't say they were a quarter of a mile away, 10 miles away. He said, I know they're posted, I can't tell you where.
Well, he actually said he knows there's not any in the area to stop. He said that. Okay. He said, I don't think there's any that. I don't recall seeing any. He said, I don't recall seeing any 2 different times. Now, as a Lieutenant Small, he's been in the business, I think, for 20-something years. And he patrols that area. I've seen him up on down that route quite often. He, there's no speed limit signs anywhere in that area.
Let me ask you, I started calling you counsel, I'm sorry, Mr. Clark.
Yeah.
Let me ask you, I think I understand your argument, but I want to make sure I get an answer to this particular question. You said there's no speed limit sign where you were stopped. I don't think you're suggesting that there has to be a continuous speed limit sign. I mean, there could be a speed limit sign a mile before you were stopped.
Well, there has to be a speed limit sign at or near where the regulations apply in order to comply with the manual of Uniform Traffic Control Devices. That tells me, and I've driven a lot in the city since this incident, if you drive down any route around here. 77, Route 30, anywhere you go, there's speed limits between a half a mile apart and a mile. This stop took place not just in a short distance. He followed me for quite a distance before he pulled me over because he didn't want it for safety concerns. It's in the transcript. I asked him, why didn't you pull me over right away? Because he caught up to me right away. He took a while to pull me over for safety reasons. And that whole area, there was none. There's none in Westfield Township at all.
Are you, what are we to do with the fact that you admitted you were going over 80 miles an hour?
Well, there's cases, Terrence Blair out of 8th District Court of Appeals. He specifically told the officer that he was going to continue going after he said, well, I didn't see the speed limits. I didn't see the stop sign or I stopped, I think is what he said. He said that he told the officer, I'm going to keep going past here and I'm not going to stop and you can't do anything about it. This is a matter of, if I'm going down the road, there's two things that prompt me to check my speedometer. An officer in the road, you know, they're usually in the middle of the road, or speed limits. There's a notice requirement. Same notice requirement that if you were going to, in a civil action, if you were to have to sell off somebody's goods in a storage area, you have to give them a 10-day notice. The mandate, the Uniform Manual of Traffic Control Devices is given the force of law. 4511 subsection 12 says, no provision of this chapter shall be enforced against an alleged violator if at the time and place of alleged violation, an official sign is not in proper position or sufficiently legible to be seen by an ordinary observant person. And he did not see a sign anywhere.
I guess what I was asking you was the question, since you were going 80 at least, there's no posted speed limit in Ohio over 70, right?
Well, yeah, that's true, but there's posted speed limits in other states, and I do drive in other states. There's no case law anywhere in Ohio, none, that says you were going a little bit too fast. So we're gonna bypass the legislative's intent. The legislative's intent was to hold local officials responsible in order to get them to put up speed limit signs. The whole purpose of this appeal is for me to get local officials to start putting signs up, because there's too little signs out in the country where I live. If you drive around here, you don't run into that problem. If you drive in Akron, you don't run into that problem. If you drive into Cleveland, you don't have that problem. The problem is this: on Route 30, on Route 224, you could drive for 3, 4, 5 miles, and there's no speed limit signs. I thought that speed limit in that area personally was 70, because it looks like an express freeway. To me, it looks like maximum speed limit right there.
And you're charged with posted violation, so.
Yes.
And I don't dispute that, and that's what we have to look at. But I think to some extent, Judge Carr's point is taken that I appreciate you thought it was probably 70, you were still going 80. Even if we're not gonna, that's not gonna factor in our decision, understand the speed limit wasn't 80.
Yes.
And you shouldn't be going 80.
Yes.
Having
And
said
that's-
that, I appreciate we need to look at this charge, and the question here is, was there a posted speed limit
Right,
sign?
right.
And you're saying, and you told the trial court, as I recall, there wasn't a posted speed limit sign.
Yes, that's in the transcript.
Because we're limited to what the record says, so we can't say, did you go out and look at it since then? We can only say, what did you tell the trial court? And the trial court, I think you told them, there's no posted sign.
Yeah, and he said I don't believe there's any posted speed limits in that area. Didn't specify exactly what area he was talking about. I don't recall seeing any, and then when I further questioned him, okay, so is it your testimony that you didn't see any posted speed limit? He says something like, I don't think there is any, I don't recall.
What I think, what I thought you were talking about at the time was two different things.
Huh.
One, after he saw you and before he pulled you over, that there were no signs from that point. So here's where I saw you, here's where I pulled you over. And you were asking him, hey, were there any signs between where you saw me and where you pulled me over?
Yeah,
I think he was saying, I don't think there are, I don't remember any.
yeah,
But there's a separate question to me, that's all well and good. There's a separate question, before you got pulled over and you're driving down the road, where was this posted speed limit sign? Was it a mile before that, 2 or 3 or 4 or 5? And you're saying, hey, there weren't
There weren't
hardly
any
any,
where I got done.
hardly any out there, but his testimony was, yeah, I know that, as I recall his testimony, I'll read it again from the trial transcript was, I know there's some signs there, but I can't tell you where they're at.
He said on that road, so he didn't say
Right.
in the area to stop. He referred everything to the area of the road. He was saying, I know there's speed limit signs.
You have a minute of time left for your initial
Okay.
time. Mr.
All right.
Go ahead, please answer my question, don't stop.
I'm sorry.
Please answer my question, don't stop,
Yeah.
I just want to let you have a
Okay.
minute of time left.
Yes, and so he said on that road, he never said in the area of the traffic stop. What he was saying is he knows there's signs somewhere, and he's right, because if you go a couple cities over, there's a speed limit sign. Yes, there is, because that area isn't just one city. Every time there's a new city, should be a new posted speed limit sign. It's supposed to be put at or near where the regulations apply. Being three whole entire miles away is not acceptable. I have to be put on notice that there's a speed limit for me to violate it. And that's the nature of my argument. They violated, the local officials there, when I'm all done with this, I'm gonna go to all these different cities, I'm gonna make them put speed limit signs up. That's my goal here. Because
Mr. Clark, you're into your rebuttal time now, you can
Okay.
keep going if you want, or you can save it, it's up to you.
yeah, well, that's my goal here, because it's not right to create speed traffic for motorists. And State versus Arnold said, in order for a pedestrian or for a motorist to violate a sign or a regulation, there has to be one posted. I have to know, I can't think it's something else. And when I went down there, I'd never imagined it was 60 down there, because there's no signs, none. And it was very good, I'll tell you what, it was very difficult trying the case, because every time I said something, I was being objected to. It was I'm not an attorney here. It's very hard for me to argue this, but there is no case law in Ohio that says, I mean, they have where the sign's 2 inches shorter. How about, Menor versus Mills? All the signs were a little bit shorter. They didn't say they didn't see the sign. And those cases were reversed, because they said, you didn't comply with the Ohio Manual of Uniform Traffic Control Devices. And I violated the posted speed limit, and I was found guilty of it, and there's no posted speed limit for me to violate.
Thank you, Mr. Clark. Oh, yeah, yeah, sit there,
I think I
and
like
you'll get your rebuttal times, you can hear what he had to say and then respond to him.
Okay.
So you don't have to leave, but we would like to hear from you when he's done, okay?
Yeah.
Thank you, Mr. Clark.
Good afternoon, judges. My name is Jared Roberts. I'm the Assistant Law Director and Prosecutor for the City of Wadsworth. I'm here on behalf of the state. I was not the prosecutor at the trial court level, however. So I think, I understand that this is a violation of posted speed limit signs, so I won't spend a lot of argument, but I think Judges Stevenson and Judge Carr both caught on the fact that it's undisputed that Mr. Clark was going 80 miles an hour by his own admission, by the testimony of Lieutenant Schmoll, and there's no posted road anywhere in the code that would allow for that speed, so even if you thought it was 70 miles.
Well, does that matter though? I mean, he's violated the posted speed limit. You gotta show it. He's arguing either not a posted sign. He could be going 114, it doesn't matter, it's gotta be a posted sign.
I would.
I mean, just for his benefit, don't do that. I was saying that,
No, no,
don't
no.
do it in the future, but there's gotta be a posted
So I
sign.
understand that that's the issue and that's the charge here. And so the question then is, did the state meet its burden of production to establish that the speed limit on that road was in fact 60 miles an hour and not 80? And I believe that the state did. So Mr. Clark brought up the Kurtz case, and in that case, I think it's factually distinguishable here because as the trooper in Kurtz testified, he had a general belief that the speed limit on a quote-unquote country road was 55 miles an hour. In this case, Lieutenant Schmoll didn't say I have the generalized belief. He said, I know that section of 224 is 60 mile an hour zone. And then,
Did
again,
he say he knew it was posted?
when asked if there were posted signs, again, I think this is different than in Kurtz because he says, yes, I'm aware that there are posted signs on that section of road. And Judge Stevenson, I believe, I understood that, I wasn't the trial attorney, but I understood the testimony from Lieutenant Schmoll to be the same interpretation you gave it, which is, I can't tell you the exact mile markers, but I'm aware they're posted at regular intervals along that road. And again, that's different than Kurtz, because I think the footnote in Kurtz said, the speed limit sign was not posted for some 15 miles, and it was posted well after the area of the stop.
And
Here-
Kurt wasn't it was D1, not D5, so it wasn't necessarily a posted speed limit case anyway.
That's correct. But, I think what Mr. Clark is arguing is that, absent the posted speed, which I believe there's enough in the transcript from Lieutenant Schmoll that says the posted speed was, in fact, there were signs, and it was more than a generalized belief of the road, it was a specific knowledge of the speed on that road. But I think part of Mr. Clark's argument is that absent the posting of speed, there should be some indication or some testimony of what type of roadway it is, so that we have then fall back to the code. So in other words, the speed limit sign sets the prima facie lawful speed, and that's determined by, the director or local authority.
Is it your testimony that if there had not been a posted sign under D5, that you could still charge him with an offense because he was going 80 when there's no posted sign?
Well, I'm not sure if I'm arguing that, but I'm saying in light of this court's decision in Kurtz that said, okay, absent a posted speed, the state should have to provide some testimony about the roadway. I think that's logical and does hold the state accountable then, and sets a reasonable burden. What I think is unreasonable is to have require law enforcement to be able to say on every stretch of road within their jurisdiction, this is the mile marker where the speed limit is posted, and then, further to Judge Carr's point, how often do they need to be set? And I didn't do a deep dive on that. I think the Department of Transportation in Ohio says every 10 miles, but that's not on the record. So, but what I'm saying is, how often do they have to be posted then? What's reasonable? Because if
Counsel, under this part of the statute, because you just said absent a posted speed, we have to say what kind of a roadway it is. But the D5 says exceeding the posted speed on a highway, expressway, or freeway. So do you still have to have testimony about what type of road it was, even if you have a posted speed?
No, Judge, and I apologize if I'm being unclear. I'm saying the point I'm trying to make is that the logic in Kurtz was that there was no posted speed.
Right.
And so then having the states provide that additional information about the type of roadway, that makes sense, and that does hold the state accountable. And that's a distinction in this case. It's factually different because there are posted speed limit signs according to the testimony of Lieutenant Schmoll. And then along with his not generalized knowledge of the speed on that road, but his specific knowledge and familiarity with that road, that the posted speed is 60 miles an hour.
And it might seem a little off campus here, but, because we do these speeding cases on a regular basis, but it does say in the statute, upon a highway, expressway, or freeway. So again, if you had a sign, do you also need testimony of what type of roadway the speeding violation occurred?
I don't believe so in that
Okay.
case. That's what I'm saying. But I do understand the court's reasoning in Kurtz. I just think that they're distinguishable for that reason, Judge.
I understood.
I guess I was just gonna ask you, so there was nothing presented, obviously, I'm not saying that an officer has to identify the specific mile marker or only stop somebody where there's a speed sign, but at the same rate, was there any testimony whatsoever in regard to how often they appeared on this road or what the requirements are? There has to be some kind of requirements as to when, to make it reasonable.
Judge, there was no testimony about what the intervals were. The testimony from Lieutenant Schmoll was that he was aware that there are posted speed limit signs on that road. He couldn't say exactly where. But again, I take that testimony in context to mean he couldn't give you the mile marker, but he knows it's posted at regular intervals.
Was there a testimony that there were different speed limits on that stretch of road?
I do not believe there was. I would have to look at the transcript, but to my recollection, there was not.
Thank you.
Unless there's any other questions, I don't think I have anything further from the state.
Thank you, Counsel. And now you have your rebuttal time, Mr. Clark. About 3.5 minutes of rebuttal time left, sir.
Okay.
Come on up, please.
In his case that he had provided, State versus Caston said that in the absence of a posted speed limit, it seemed necessary that the state would be required to established the prima facie speed limit under ORC 4511, 21E1 through B17, which is actually now 16. And, but when the Director of Transportation or local authorities establish that speed, and it is posted, such a showing is unnecessary. So, in this case, what they should have been required to do if they want to prove their case, and this is notwithstanding the violation of the manual that I'm alleging, that's an extra thing, that's icing on the cake, because when I was found guilty of exceeding the posted speed limit, they should have known that they had to go drive down that area. I showed up for the court trial one time, and the officer never showed it, they didn't dismiss it. I took off the whole day of work. Then the time he did show up, that officer should have drove down that road and should have seen that there was no speed limit signs. He should have done that too if he's gonna try a case, he should know what he's talking about. And in State versus Cass, so basically it says that it makes sense to testify to the nature of the roadway. They could have done that, they didn't do that. They could have found somewhere between B1 and B17, or B1 through, or D1 through D4, and established the speed on that roadway, and they failed to do it. And he never said there was a posted speed limit saying 60 miles an hour. He said he knows the speed limit is 60 miles an hour, and he knows there's signs somewhere posted, yeah, 5 miles down the road, not anywhere I drove. So, I mean, that's what we're looking at. So his own case stipulates, there's case law on this, there's some case law out of Akron, there's some case law out of Akron Municipal Court, where they said the exact same thing. They said they should have amended the charges. Because what happened was, one of the cases in Barberton Municipal Court, I think it was, or Akron, where they actually amended the pleadings before the trial. And then they thought, because they didn't have proof, because they knew better, that if you don't have a posted speed limit, then you have to establish the nature of the roadway, of the prima facie speed limit, on B1 through B17. That's how you have to do it. They didn't do it either. And that city has violated, there's 3 different areas out there. It goes from Harrisville Township to Westfield Township to Westfield City, back to Westfield Township. At the very end of that, I'm on this end, on the very end of that is a speed limit sign. I always thought there was 70 down there, until you got to the other side of where the building that burnt down, the Westfield Township building that's right up close to the road, where there's an actual speed limit sign for the first time. That's where I thought the speed drops. I was in a hurry. Her father bled out, okay? He has these bleedings from diverticulitis, and he was going over to go jack up a trailer that I told him not to jack up. And I was scared he was gonna go over, jack up the trailer, and back in the hospital, maybe even not make it. I was in a hurry to go get there because he wouldn't answer his phone, to go over there so he doesn't bleed out again. That's why I was doing 80 miles an hour for her father, so he wouldn't die, because he had already been in the hospital and almost passed. That's where I was going.
And your rebuttal time is up, Mr. Clark.
Okay,
You can briefly conclude, or we thank you for your argument.
thank you. I appreciate it, everybody.
The clerk will take the matter under advisement and issue a decision in due course. The clerk of court will mail a copy of that decision to you once released.
Okay.
It'll be available on the Ohio Supreme Court website. With that, I'd like to thank both of you for your presentations today. And note that the court is now adjourned until